friends, welcome to my channel. This is Mahesh, practicing company secretary based on Ahmedabad. So let's start with our continued subject, that is Jurisdiction of Tribunal under the Companies Act 2013. In my earlier videos, we have gone through several sections, that is section 7, subsection 7, section 48, section 55, section 58, 59, 61, 62, 66, 71, 9, 71, 10, 73, 74 and 76, where the jurisdiction of the tribunal vested. Now let's go further. The another section where the jurisdiction of the tribunal vested is section 90. As we all aware about that, section 90, it's all about the intimation of the significant beneficial ownership in the company. So wherever the individual holds the significant beneficial ownership in the company, needs to require to give the declaration in band 1, and in turn companies file the said declaration with the ROC in band 2. So in which the section 90, the jurisdiction of tribunal vested, that start with the section 90 subsection 5. Section 90 subsection 5 states that wherever the company needs to require to give the notice in a prescribed form, that is band 4, to the person, whether that person is a member or not, where the company having the reasonable cause to believe that the said person is the significant beneficial owner, or having the knowledge that who is the significant beneficial owner, or have been a significant beneficial owner during the past 3 years preceding the date of service of notice. Then in such a case, company having the reasonable cause then serve the notice in band 4 and ask that person and why he has not registered himself to be the significant beneficial and not filed to the company's significant beneficial ownership declaration. That stated in section 90 subsection 5. In 90 subsection 6, the period specified, the said information needs to require to be given by the said person within a period of 30 days. 90 subsection 6. 90 subsection 7 states that if the company has not received the said information within the time prescribed under the period in the notice, or whatever the information that has been given by the said person is not satisfactory, then within 15 days from the expiry of the period, company may make an application to the tribunal and move before the tribunal for the direction with regards to the restriction on the said shares which are in question, and the restriction with regards to the right attached with the shares, that is right with regards to dividend, rights with regards to voting rights, right with regards to the participation, right shares, bonus shares. So restrictions, transfer of interest, so restriction on all such rights attached to the shares which are in question. That is 90 subsection 7. Within period of 15 days time limit is make an application. 90 subsection 8, tribunal after giving opportunity to both the parties decides that whether the declaration is required to be given and whether the declaration has been filed or not, and after giving the opportunity of being heard, made an order and restrict the rights attached to the shares within a period of 60 days of the receipt of application. So 15 days is the time limit for filing an application. Within 60 days, the tribunal give an order, pass an order. 90 subsection 8. 90 subsection 9, it states that within a period of 1 year, the company or aggrieved person make an application for the lifting of the restrictions imposed by the tribunal on the shares which are in question within a period of 1 year, and if within that 1 year no application has been made for the lifting of the said restriction, then the said shares are transferred to the IPF, which has been constituted, IPF authority which has been constituted under section 125 subsection 5 of the Companies Act 2013. So this is whole where the jurisdiction lies to the tribunal under the Companies Act 90 subsection 7, के जहाँ पर अगर कंपनी को लगता है कि यहाँ पर सिग्निफिकेंट बेनिफिशियल ओनर है और अगर वो इंटीमेट नहीं करता, कंपनी मूव कर सकती है बिफोर ट्राइब्यूनल फॉर रिस्ट्रिक्शंस, and then if within 1 year if no application made for lifting of that, then shares are transferred to the IPF. Now the corresponding rule under which the company make an application for to impose a restriction, to get the direction of imposing restriction on the said shares, and that is, there is no specific rule which has been prescribed under the NCLT Rules 2016 with regards to the format of application, and that's why the general rule, and that is Rule 88, where it has been prescribed that no separate format has been prescribed. Then NCLT 9 the format in which the application made. And the supporting annexures here in this case, that may be where the company served the notice, so that notice format, this proof of service, proof of delivery, then whatever the response that has been received from the said person, that response, and the registration document, the shares and equation, that shares, details of that shareholders information, details, document evidence on which the company having the reasonable cause to believe that the said person is a significant beneficiary. So all these annexures that are supposed to be made, along with that the supporting draft that are supposed to be made, that is affidavit and all this stuff. Now in this, the case law, there is a case law is in one of the case that the individual holds more than 10% of the shares of the company, and out of which some part of the shares that he has been pledged to the another person, another shareholder, and has also same intimate to the company that he has been pledged his shares, to the another person, after which the company has issued the notice to the pledgee that he has not filed the significant beneficial owner declaration, because considering the direct and indirect interest, he is holding the interest in the company more than 10%, and that's why he need to require to give the declarations. As a result of which, the company has issued the notice under section 90 subsection 5, against which the response has been received from the pledgee, stating that the shares which are in question are still in the name of the pledger, and that's why he is not required to give the declaration. Against which the company move before the tribunal, and the tribunal, after considering the case and considering the facts, comes to the conclusion that the shares which has been pledged to the another shareholders, under which along with the shares, the rights attached to the shares is also been pledged, and the rights exercised by the said pledgee, and that's why the pledgee have direct plus indirect interest, and that's why you need to require to give, and which is crossed beyond the threshold limit which has been prescribed under the rules framed for the significant beneficial ownership, and that's why you need to require to give the declaration. As a result of it, direct the pledgee to give the declarations until the time the rights attached with the shares are suspended. So this can be the case, this will be the case for where the jurisdiction of the tribunal line, that is section 90 subsection 7. The another section where the jurisdiction lies, that is section 97. 97, as we are aware about that, 96 it's conduct of AGM, and 97 important verdicts is 97 subsection 1. If any default is made in holding the AGM as prescribed under section 96, then in such a cases the tribunal, notwithstanding anything contained in the act or articles, on the application of any member of the company, call or direct the calling of an AGM of the company and give such ancillary directions that is required, and also that direction includes direction that one person present in the meeting, one member present in the meetings, either in a person or proxy, constitute the valid meetings. And the corresponding rule under the NCLT prescribed the format of application, and the rule is Rule 74, where the format of application, where there is a default has been made in a conduct of AGM, then any member make an application, and the format is NCLT 1. And the supporting annexure is company's registration documents, company's last year forms. The important thing is last year form, why the company is not made a default. Either that is because of deadlock in the management, all the directors are disqualified, all the directors have resigned their post, and that's why company is not in a position to call the AGM, and the due date comes closer as prescribed under the Companies Act, and that's why any member of the company move before the NCLT in a format of NCLT 1. So supporting annexures that are supposed to be made, that is last year forms, registration documents, and documentary proof why the company is not in a position to conduct the AGM. And the company needs to require to serve the copy of application to the ROC, and ROC report required, and after which the NCLT give the directions how the AGM will be required to be conducted. So here the case to maybe is that all the directors are disqualified. So in that case, all the directors resign. In that case, if only one director is present, so for to call the AGM there is a recorded board meeting, and for the meeting there is requirement of 2 directors, and that's why any member may move before the tribunal to get the direction of the tribunal to call the or direct the and conduct the AGM. Now, but another case though, interesting case though, In one of the case, there is a 3 shareholders, out of which one dies. So 2 remaining, out of which 2, the one is deliberately not attending the AGM. Several notice has been issued. The notice of AGM has been issued to the member, to concerned member, is deliberately not issued, and that's why the meeting is goes adjourned because of want of quorum. In adjourned, AGM also is not attending and deliberately is not attending meeting, as a result of which the meeting is not validly constituted, because for to conduct the meeting there is requirement of 2 members. Here only 1 member, because one other member is not deliberately attending the meeting, and that's why the remaining member move before the tribunal for to get the direction of the tribunal to call hold and conduct the AGM, and also to get the to issue the direction that one member present in the meeting constitute, either in person or proxy, constitute the valid meeting. So along with that, the application attach the relevant proof, that is the notice has been served to the member, but he has not deliberately attended the meeting, and after considering the same, the tribunal issue the direction and issue the notice that to call and direct the meetings, and the valid person, the member which is remaining, the present in the meeting, that one member constitute the valid meetings. So this is the case where the jurisdiction of tribunal vested. Here the important thing that has been specified in section 97 subsection 1 is, if any default made in the conduct of AGM, holding the AGM as per section 96, that means if the company has conveyed the AGM as per section 96, but there is a default has been occurred, means company has conveyed the AGM, conduct the AGM, but there is no proper quorum, but director has been specified that the quorum is there and has filed the forms, and as a result of which the shareholders agreed with the same, move before the tribunal and place the facts, and in which the tribunal, after considering the same, tribunal give the direction to again call the meeting, direct the AGM and to conduct the AGM. So here this section is also gives rise, the jurisdiction is vested where the AGM is not conducted as per section 96. The example I have given, that quorum is not present. The proper voting also has not been provided to the shareholders, so shareholders may also move before the tribunal for the same. So it is not only the case where there is a deadlock in the management and move before the tribunal, there is also the case where the AGM is not being conducted as per section 96, then also any member of the company may move before the tribunal in format of NCLT 1 and get the direction for to conduct an AGM. So this is the case where the jurisdiction is vested to the tribunal. So the similar case, that is section 98, where the jurisdiction is also vested to the tribunal, where it has been specified that 98 subsection 1, if for any reason it is impracticable to call the general meeting other than AGM, as per the articles, as per the manner which has been prescribed under the Act, then in such a case, the tribunal on suo motu either, or an application made by any director or any member who is entitled to vote, order a meeting of the company to call, direct and conduct the meeting of the company, also issue the consequential directions that required, and including that direction that one member present in the meeting either as a person in person or proxy constitute a valid meeting. And the corresponding rule is rule 75, where the format of application remains same, that is NCLT 1, and along with that application supporting annexure, that is deadline in the management, proper company's registration documents, all this supporting documents, supporting drafts that are mandatory supposed to be added, that is affidavit and all this stuff. And copy of application need to require to serve to the ROC, and after going through the ROC report and tribunal gives you order. So here also the case is same that we have seen for the section 96. The deadlock in the management and the company is not in a position to call the meeting, and here if all the directors have resigned, all the directors are disqualified, so to call the board meetings also there is required of 2 directors, and because for to appoint the directors, or every director appointed in general meeting, and that's why also need to call the general meeting, and for to call the general meeting there is a requirement to call the board meeting, and that's why can also move before the tribunal for to get the direction of the tribunal to call the general meetings for to appointment of the directors. So this is the section where the jurisdiction of the tribunal vested, and here I also would like to state that where there is a below the quorum directors are there in the company, in such a cases for to appoint the directors which are required for the quorum, the one director also can call the meetings of general meeting to appoint the directors, for the appointment of minimum number of directors prescribed under the Act. So here also the case where the alternative is there, as I have told you, refer 174, where it has been prescribed that even though the minimum number of the directors under the Companies Act, directors of the company below the quorum, below the prescribed under the Act, but can conduct the general meetings for the appointment of directors to fulfill the quorum which prescribed under the Act. So this is the case where the jurisdiction of vested, that is 98-97. Let's go ahead with another section, and the section is section 119. 119, it's all about the inspection act, extract of minutes. Wherever any member wants the minutes of general meeting, because no person can demand the minutes of board meeting except the statutory authorities which are also under jurisdiction of tribunal. Other than that, no person can demand the minutes of board meeting, and that's why if any member wants the minutes of wants to inspect or wants to get the extract of minutes of general meeting, then in such a cases he can demand from the company, and during the business hours that may be prescribed under the articles, but that should not be less than the 2 business hours as prescribed under the company. And for to get the extract, the company may charge, but should not be more than 10 rupees per page. And within 7 days from the request, company is required to serve the copy of that extract of minutes. And in such a cases, if company refuse and the company may default and not provide, then in such a cases member may move before the tribunal and get the directions of the tribunal to the company to available the inspection or to serve the copy as requested by the member, and for which the relevant rule under the NCLT, that is Rule 76, and the format of application is NCLT 9, and the supporting annexure that may be the annexure that supporting annexure that are when you demand the company, so the proof of request letter that you have made to the company, that you have filed to the company, whatever the outcomes received from the company, and for which general meeting that you required the company's registration documents, so that are the supposed to be annexure that has made, and other document that we all are aware about, the draft, that is affidavit verifying petition or opinions and all this stuff. So this is the case where the another jurisdiction of tribunal vested, that is section 119. Section 96, 97, 119, section 90. Now let's go for another section, and that is section 130. The section is 130, and as we all are aware about section 130, it's about the reopening of books of accounts and recasting of the financial statements. So 130 subsection 1, it states that no company can recast its financial statement and reopen its books of accounts when it is done, when it is filed, unless an application in this regard is made by the statutory authorities, that is income tax authorities, SEBI, central government, ROC, or any person concerned to the tribunal, and when it is proved that, when the tribunal has effect that prove that the accounts were prepared, earlier accounts, relevant accounts were prepared in a fraudulent manner, or the affairs of the company were mismanaged during that relevant period, and that creates a doubt on the reliability of the said financial years, for the financial years which are prepared during the said year, relevant period. So this is all the case, but before passing the order, the tribunal give the opportunity to the statutory authority, SEBI, ROC, income tax, central government, if they want to make any representation, and after considering the same, pass an order that is either admit the application and direct for the recasting, reopening of books of account, recasting of financial statements, or dismiss the application. But the said books of account that should be for the period relevant for the period of 8 years before the date of making application. Now, what will be the corresponding provisions? The corresponding provision under the NCLT Rules 2016, and that is Rule 76A, where the manner of application is NCLT 9, and here the supporting annexure that are supposed to be made, and that is the forms which has been filed and on the basis of which you are challenging the grounds on basis of which you are challenging the affairs of the mismanagement, to document evidence with the said regards. The accounts were mismanaged, prepared fraudulent manner. It has been prepared to the proof with regards to the fraudulent paper, because books of accounts if say different and financial statements say different. So you can both attach with the application, and along with that the mandatory supporting documents. So this is the case, this is the manner of application, that is NCLT 9. Along with that, the attachments, mandatory attachment that are supposed to be made, and this is the case. And here, so section 130, it's all about when the concerned person, central government, statutory authorities, ROC, SEBI, RD make an application to the tribunal for the reopening and recasting of the books of accounts and financial statements. Then tribunal gives an order after opportunity giving to the company and parties, that is statutory authority concerned. After considering them, give to pass an order. Now what is the case law? And here the case law, as we all are aware about the prominent case law and well-known case law, that is Island FS Group. Island FS Group. In Island FS Group, what happened is that the central government moved before the NCLT, Mumbai bench, Union of India through regional directors for the reopening of books of account and recasting of financial statements of Island FS Financial Service, Island FS Transportation Networks Limited for 5 years. All this is started when the ICRA Accrediting Agency has downgraded the long-term loans and debentures of the Island FS Group from AAA to AA+. And where the central government looked into it, then find out that the large public money involved in the said group, and that is estimated around 90,000 crores. And that's why the central government has initiated an action and has appointed SFIO for the investigation into the affairs of the INFS group, SFIO. And after that, ROC has also initiated an action in inspection inquiry under section 206. Also ICAI has initiated action, and after the report of both, it was found out that the affairs of the INFS group has been mismanaged, because they have raised so much of borrowings from the public sector banks, financial institution. They have made a default in a commercial paper borrowings, short-term borrowings, intercorporate deposits, and they have showing a rosy picture of the financial statements, and there is a large mismatch between the cash flow liquidity and the statements showing to the public negative cash flow. And that's why the central government moved before the NCLT Tribunal bench and NCLT Mumbai bench, and NCLT Mumbai bench, after at the first hearing, give the direction to the petitioners, Union of India, to serve the notice to statutory authorities, and after hearing the companies and statutory authorities pass an order for the reopening and recasting. Here the ground is not Union of India has initiated action. That's why here the ground is the affairs of the company is mismanaged, because there is a proof, there is a large difference between the liquidity, mismatch between the cash flow, and that's why they on the said grounds the NCLT pass an order for the recasting and reopening of books of accounts. So on the two grounds, the action can be initiated then the affairs of the company mismanaged or relevant earlier accounts were prepared in a fraudulent manner. This is the prominent case though, but the another case though, in which in one of the case it happens that the directors have diverted the company's fund to their partnership firms, and also done the sales on a cash basis. Majority of the sales and done on a cash basis, and that's why because of that also the incident occurred where the GST notice has been received on the company, and suddenly the shareholders of the company have observed that the company has made the net profit in a previous year of rupees 3 lakh and having the physical stock positive, showing in this current year net profit of 17 crore rupees, and also the negative stock, because of the measure of negative stock. And that's why on inquiry it was found that there is a mismanage occurred in the company. That's why they have moved before the NCLT Tribunal, as because mismanage is there, and that's why the section 241 242 trigger. But along with that, they also demand the prayer for under section 130, and that is for revision and recasting of books of account, because it affect to them, and that's why they move before the tribunal. So this is all the case where the jurisdiction lies, that is section 130, where any person concerned and central government statutory move before the tribunal for the reopening and recasting, reopening of books of account and recasting of financial statements. So that is the case where the jurisdiction lies. The another section is section 131. 131, it's all about the voluntary revision in the financial statements or board report. So company voluntary can make an application, but for the revision in financial statements, where the financial statements, where company came to found that the financial statement which has been prepared for the real financial year, and that is not beyond the 3 preceding financial year, any of the 3 preceding financial year, not in accordance with the 129. 129 is all about the financial statements, and the financial statement should be in accordance with the, should prescribe and should follow the 133, that is whatever the accounting standard which has been prescribed in section 133 should follow that. So where the financial statement not prepared in accordance with the 129, or the board report which has not been prepared under section as per section 134, which has been prescribed the content of the board report, and where it has not been prepared accordance with that, then company later on, if it came to found the same, then may make an application before the tribunal for to get the order of revision, to make the revision in the financial statements or board report, and for to adopt and file the same, the revision with the ROC. In that case, the before passing an order, the tribunal give the direction to the company to serve the notice to statutory authorities, and after serving the notice to the authorities and after considering the representation of them, the tribunal pass an order for the same, either allow the company to make the revision or dismiss the application. Now the relevant rule, where the relevant rule which has been prescribed under the NCLT rules, where the manner of application has been prescribed, that is rule 77. Rule 77, the manner of application is NCLT 1. The first application should be filed within a period of 14 days from the date of decision taken by the company, where that they want to make an application within 14 days. The supporting annexures that are supposed to be made with that NCLT 1, that is for period for which the financial for which you need to file the application. So that financial statements or board which has already been filed, that's report. The ground with the section 134 provision, 129 provision which has been contravened by the company. Last year forms registration documents. Along with that, if the said account, if the said financial statement which has been prepared and which has been audited by the earlier auditor, and auditor changed the details of that said auditor, if the board report which has been prepared by the earlier directors and director changed, then details of that earlier directors, and because the tribunal by passing an order give the opportunity to that earlier directors and earlier auditors, why the contravention has been occurred, why the contravention has been made, justify that, and that's why need to require to mention the details of the same if the change is occurred. After which, at the first hearing, the tribunal give the direction to the applicant company to publish the notice in a newspaper. Then before the at least 14 days before the next date hearing, company is to require to publish the notice in accordance with the rule 35, where it has been format prescribed, that is NCLT 3A. And after which the need to require to serve the notice to statutory authorities, and tribunal after hearing the companies and after considering the representation if made by the statutory authorities, pass an order for the revision and dismiss the application. After the order passed, the company is to require to file the said order within period of 30 days from the approval order with the ROC in a form NC28. Not only that, also direction has been given by the tribunal to call the general meeting. And where the general meeting has been called, the company needs to again require to publish the notice in a newspaper, English and vernacular newspaper, with regards to the decision has been passed by the tribunal for revision in a financial statements and board report for which year, and the general meeting has been scheduled for the adoption of the same. And in the said general meeting, the first decision has been taken what confirmation which has been made, why the revision application has been made, what the revision has been made, after which the adoption of financial statement made or board report has been made. And within 30 days from the revision, adoption of that revised financial statement or revised board report, companies to require to file the same with the ROC in the relevant form, that is AOC for MJT7. So this is all the case where the jurisdiction line where the company may make an application voluntarily if the financial statements of earlier year but of any of the three preceding financial years not prepared in accordance with section 129 or 134 board report. The case though can be that in one of the cases it happens that the company has misinterpreted the new concept of Ind AS, applicability of Ind AS, and because of in that misinterpretation in the applicability of the Ind AS, company has not followed the Ind AS applicability and prepared the accounts without applicability of Ind AS and not mentioned the same in audit report and filed the same. But later on, the company has came to conclusion and came to found that for the said financially Ind AS is applicable, and that's why the company voluntarily make an application. Because if later on it will be found by the authority, then authority may impose the action, may initiate the action, may impose the fine, and that's why the company voluntarily make an application and get the order for the revision in the financial statements. Because the company is of assumption that in a previous year the net worth is below the criteria and that's why the Ind AS is not applicable, but the company later on came to found that in last year the company has crossed the limit of net worth and that's why the Ind AS is applicable for the said financial year. That's why they make an application. So this will be the case where the jurisdiction lies to the tribunal, where the company may make an application, Ind AS applicability, accounting standard applicability. If company is forget to follow the accounting standard, forget to follow that treatment, then also make an application and get the order for the revision in the financial statements. For board report also may be possible. In one of the case, one of the scenario, it may be possible that where the Companies Amendment Act came, Amendment Act 2017, where it has been prescribed under section 134 to only prescribe the web link where the extract of inheritance has been uploaded. So if there is no website, then some of the professionals are of assumption that now there is no requirement to attach the MJT9 and have filed. So in that case, later on they have came to know that if there is no website, then it has to be attached with the attached the board report. That's why in such a cases, the professional also may make an company may make an application for the revision in the board report and comply with the 129, because to cure the company from the further prosecution, from the future prosecution initiation action. So this is the case where the jurisdiction lies, that is section 131. So in this video we have gone through where the jurisdiction lies, that is section 90, significant beneficial, section 97, AGM default made, 98, EGM when company is not in a position to call the EGM, 97, 98, 130, 131, 130, that is central government make an application, any statutory authorities make an application, and any person concerned pass an order, where 131 company voluntarily make an application, then also go for the revision in the financial statements and board report. So that's it for the day, but the subject here not ends because it will remain continue. So till that, stay connected, stay happy and stay safe. And if you have not subscribed channel, then don't forget subscribe my channel to get the notification of my upcoming videos, because after completion of this subject we also will go to the jurisdiction of the tribunal under the IBC, जहाँ पर उसका नाम है adjudicating authority. Then also with regards to the pre-packaged insolvency. So till that time, stay connected, stay happy and stay well. Thanks.